Hello, my name is Charlotte Fleming and I am a solicitor in the Wills, Estates and Succession Planning team at BTO. Today, I will be dispelling myths which are widely believed in relation to wills and succession issues across the population. Many people believe that they do not require a will due to their personal circumstances. However, in many cases, this belief is incorrect. Anyone who dies without a will is referred to as having died intestate, and in Scotland, dying intestate can have many unexpected and often unwanted consequences. I will go through a number of myths in turn, and in each case, explain why the myth is not true. Myth 1. I don't need a will because I'm too young. Many people believe that creating a will is not something they require to think about until they are elderly or unless they are very unwell. However, having a will is important, as should the worst happen and you were to die suddenly and unexpectedly, you would want to have peace of mind that your wishes would be complied with upon your death. Particularly if you have young children, you'd want to choose a guardian for them within your will. Myth 2. I don't need a will because I do not own sufficient assets. It is widely believed that only those with a large amount of assets require a will. However, this is incorrect. For most estates, unless the estate is less than £36,000, executors require to be appointed. If there is no will in place, the court require to appoint an executor, which necessitates additional expense and causes delays in winding up an estate. Having a will is also a useful way to pass assets which have sentimental value. Myth 3. If I die without a will in place, my spouse or civil partner will inherit the entirety of my estate anyway. This is unfortunately not true. Whilst a spouse or civil partner will inherit part of the estate, they will not inherit its entirety. Children will also have an entitlement to part of the estate, and if you are not survived by descendants, your siblings and parents will be entitled to part of your estate too. Myth 4. If I die unmarried and without a will, my cohabiting partner will inherit the entirety of my estate anyway. Unfortunately, this is not the case. Cohabiting partners do not have any automatic right to their partner's estate, and if you die without a will in place, your partner will require to apply to the court after your death and request that the court awards them a monetary sum from the estate. Myth 5. I cannot make a will as I am not ready to make a final decision in relation to my estate. It is a common myth that you can only make one will in your lifetime. This is untrue. Wills should be viewed as living instruments and should therefore be updated as and when your personal circumstances change. For example, purchasing property, marriage, parenthood, separation, and divorce. Myth 6. My spouse or civil partner and I have separated, and due to this, they will have no entitlement to my estate. It is true that divorce, dissolution, and annulment of marriage revokes any benefit conferred by a will or appointment as executor. However, separation does not have the same effect. Therefore, it is important that you update your will for the time period between separation and finalised divorce. Further, if you do not have a will in place, your spouse or civil partner from whom you are separated will be entitled to a proportion of the estate. This entitlement lessens, but does not extinguish once a will is put in place. Many thanks for taking the time to watch this vlog, and if you would like to put a will in place or wish to discuss inheritance planning, please feel free to get in touch with me at cfl@bto.co.uk or through our website, btopersonal.co.uk. Thank you.